The New York State labor law, as it relates to personal injuries, involves a very broad statutory series of protections from unsafe construction sites that also includes activities such as maintenance of the workers who are working on these construction sites. There are several different labor laws that are utilized for the area of personal injury. Most people, when you talk about labor law, they think it involves employment or contracts or employees' rights or employers' rights. But New York State, more than 100 years ago, recognized that employees working on construction sites are involved in ultra-hazardous activities and wanted to protect the workers in case they get injured. Because generally, when workers are working on construction sites and they get injured, they get really badly injured. Workers' compensation is not enough compensation to protect the worker and their families from the kinds of injuries that most workers receive when they're injured in construction sites. So starting back in the 1800s. So starting back in the late 1800s, the New York State legislature started crafting laws that were designed to protect workers involved in accidents at construction sites. And as you can imagine, over the last 130 years, the law has evolved, but it's actually gotten, for the most part, improved. The New York State labor law exists because the New York State legislature, in their wisdom, starting back in the late 1800s, realized that workers working on construction sites were getting very badly injured and needed to be compensated, and their families needed to be compensated in the event that the injuries were so bad that the worker couldn't work, or worse, if the worker passed away. So they enacted a series of statutes that are truly unique in this country, and New York State's the only state that I'm aware of that has such strong labor protection laws to protect the workers if they're injured on construction sites. When you ask someone, what is so distinctive about the New York State labor laws? The one thing that comes to everyone's mind is the Labor Law 240. The reason being is that Labor Law 240 is often referred to as a strict liability statute, meaning that the owner or contractor is strictly liable to the injured worker. That's not exactly true anymore, but it's pretty close. Over the years, there's been some exceptions that have crept into, I would say, the case law, dealing with when strict liability doesn't apply. But in reality, you give a good lawyer who's experienced in litigating New York State labor laws, and especially New York State Labor Law 240, the lawyer is always going to figure a way out of the case law created problematic situation. New York State Labor Law 240 is a very, very good statute that protects the worker involved in construction and or maintenance of a building. It also protects people that are on site, maybe passing by, like if you're walking on 42nd Street and it's a construction site and something happens, a bunch of bricks fall from above, or the scaffold collapses, or a wrench falls, the passerby is also protected under this labor law, which gives you that strict liability. Now, Labor Law 240 also does another thing that's pretty remarkable. It makes the owner of the building or the general contractor liable to the worker. And the owner of the building says, what do you want from me? I was in Hawaii. I don't even live in New York. We're not in New York. We just bought this building as an investment and hired this GC. I don't even have a presence in New York. That's not a defense. The New York State statute makes the owner liable to the worker, also makes the general contractor liable to the worker. You know why? Because New York State legislature, in their wisdom, realized that getting benefits from workers' compensation is just not enough. Not when you're really busted up or maybe pass away as a result of an accident. So what they did was they wanted to do a workaround to the workers' comp statute. And so the workaround to workers' compensation is to statutorily make the owner of the building liable, to statutorily make the general contractor liable, or make some other contractor that's in the chain other than your employer liable. What those people might do is, who cares? All we care about is making sure that we get the injured worker the maximum compensation that they're entitled to. And if you have the owner of the building that's liable, you've got the general contractor that's liable, you're generally going to be okay. New York created these laws because they wanted to protect the worker. They know that workers working on construction sites in New York State, when they get injured, they get badly injured. New York State legislature knew that workers' compensation was not a good remedy because it doesn't give the family enough money to really live like they were living when the worker was making their salary. So they needed to erect a workaround the New York compensation defense. The workaround that they enacted was to make the owner of the building liable and make the general contractor liable for any injuries sustained by the worker. New York State is, I believe, the only state that has such strong labor laws to protect the workers working on construction sites. Well, in a workplace accident case in New York State law has made the owner of the building and the general contractor and any other contractor that's in the chain of your employer liable. So if your employer is like a subcontractor who got hired by another contractor, who got hired by the general contractor, the GC, the general contractor, and the other contractor that was hired directly, they're going to be responsible to you and your family for your injuries. Likewise, the owner of the building is going to be liable. Why? Because the statute says so. It's not that the owner did anything wrong. The owner, in many cases, especially on major projects, has absolutely nothing to do with the construction site. They went ahead and hired a big GC, an international company, to do the project, to build their hotel, to build their office building, to build their condominium. They might not even be in New York. They might be in Chicago. They may never have even been at the construction site ever, but they're liable because the law says they are. And they have their remedies, and they will pursue their remedies. But the important thing is that the construction worker who's injured, their families, they're going to be protected. They're going to be entitled to damages, and those damages are going to be collectible against that owner and against that general contractor and any other contractors that are in the chain leading up to your employer. Of course, as to your employer, they're protected by workers' compensation. But you are not limited to workers' compensation in New York State for a construction site accident. You could sue the general contractor and those other contractors in the chain, as well as the owner of the building. If you're a visitor on a work site in New York State, you are covered by the New York State labor laws. An experienced lawyer in New York State who has done a lot of work in the New York State labor law is critical. If you read the case law, the defendants are always coming up with some angle to try to take away your rights. There's thousands and thousands and thousands of cases dealing with angles that they come up with and they create to try to diminish your recovery. And in our firm, first of all, we have an appellate lawyer on the staff. That's all they do is appeals. And they're reading all of these decisions daily as they come out on labor law to see what the new game is with the defendants. So we're always in tune with their games. And we make sure that we plead our case and our complaint in a way that they're not able to play games with our clients. And when our clients show up for depositions, they're ready for the games that the defendants play because we're well aware of those games. And they're not going to get away with them in our firm. A New York State labor law injury runs the gamut. I mean, you might trip and fall over a pipe on the ground and pull a ligament or a tendon. Maybe you broke a bone. Maybe you fell off a ladder or a scaffold and you broke a bone. Maybe you fell through a shaftway on the 22nd floor of a hotel that you're building and had all kinds of injuries. I had one client actually who fell through a shaftway in a hotel in Manhattan, and the shaftway was meant for an HVAC, air conditioning and heating duct. And as he held on, as he was going down, his fingers got sliced off from the tin from the HVAC ductwork. But luckily, somebody heard him screaming and was able to get there before he fell all the way down 22 floors, and they dragged him up. But by then, his fingers were already cut off, and they were just hanging there. So, and then, of course, the injuries, unfortunately, can result in death. And we've had many of those cases. So the injuries from New York State labor law violations they run the gamut from one end of the spectrum to the other.
Can you talk about scaffolding regulations in New York City?
New York City has a lot of scaffolding regulations. New York State has a lot of scaffolding regulations. They're all designed to protect the worker and the pedestrian and anyone that's on the work site or passing by the work site. Because as you know, if you've ever walked anywhere in New York State, but particularly Manhattan, a lot of times there are scaffolds covering the sidewalk where you're walking. And they're there because the scaffolding regulations require them to be there. But just because they're there doesn't mean they're going to work. If something was to fall on that protective scaffold and break through, they're going to be liable to you. Workers' compensation in New York State is generally a complete bar against lawsuits against your employer. There are some exceptions. For example, if the employer was to hit you in the head with a pipe, workers' comp is not going to protect your employer for intentional acts. The labor law, if you're injured in the construction or maintenance of a building in New York State, they allow you to sue the owner of the building or one of the contractors or general contractor because the legislature knew that you couldn't sue your employer and they knew you needed a better recovery than workers' compensation. So they enacted the law to let you get around the workers' comp defense. However, you still need to file for workers' compensation, and you want to, because workers' compensation will give you at least some money now. And you're going to need that money now to pay your rent, pay your mortgage, get food on the table, and other things like that. So you file for workers' compensation, but you also hire an experienced law firm like Parker Waichman to bring the lawsuit against the owner of the property, the general contractor, and anyone else other than your employer.